Deborah Scalise.
Thank you and good morning. My comments are limited to a very specific area. Some of you know me. I've been a former deputy counsel of the disciplinary committee, and now my career is on the other side. And what we do is proactively and defensively represent lawyers and judges in their disciplinary issues as well as other issues. People do come to us beforehand to ensure that they are in compliance. These views, first a disclaimer, these views are my own. I belong to several bar associations, I'm on several committees, but they're not their views, they're mine. They're gained by virtue of my experiences in 25 years in this area of practice. Nor are they the views of any governmental agency that I formerly worked for or my partners. They really are born of the fact of representing lawyers. And lawyers are people too, and they have issues too. What you may not know about me, that in addition to my Juris Doctorate, I hold a master's in forensic psychology. And very often, lawyers have psychological or health issues too. Hence, I'm here today to speak about lawyers with mental disabilities or addiction problems from the perspectives of my professional experience over these past 25 years. We've prosecuted and defended lawyers as well as prospective lawyers with respect to admissions and disciplinaries. They've been diagnosed and they've been treated, and I think it's very important to understand that sometimes their misconduct is not born of the fact that they're doing intentional things, but maybe they have an issue that has bled over into their practice and will explain things. Over the past 25 years, I've worked with both the New York State Bar and the Association of the Bar of the City of New York with the Lawyers Assistance Programs. And they have an anniversary in the New York State Bar, and I'd like to congratulate them on that. They have now expanded their scope. Initially, they dealt with addictions, and lawyers have addictions sometimes. But now they deal with lawyers in distress generally. What types of things do lawyers experience? They experience what everybody in the general population experiences, but sometimes it's greater because of the stress factors associated with lawyering. We are the hired guns of our clients, and sometimes when we have issues, that will bleed over into our practice. But if left untreated, these mental health issues can impact and sometimes harm clients. What my goal is here today is to educate you so that we could have some uniformity with respect to those types of things. If these mental health issues, and sometimes physical issues, like a stroke, are left untreated and are masked, they can have professional and personal consequences that can be devastating. So, due to my interest in this area, I often teach continuing legal education, and I did an informal survey, and it's part of the materials I gave you. Looking at the rules in each department, as well as the outcomes, there's a great disparity in what happens. For instance, the process has disparity as well as the rules. The facts and the reported decisions, you can see that there's a difference between upstate and downstate with respect to how lawyers with mental health issues are treated. And I gave you an outline with respect to that. Quite simply, it's not just the rules that need and procedures that need reform and uniformity, but sometimes it's the reaction to and policies implemented when dealing with impaired lawyers. My informal survey demonstrates that in a majority of the decisions, the downstate courts will give you chapter and verse about a lawyer's mental health issues or physical health issues, and they feel it necessary to give a detailed recitation of the information provided by lawyers charged with misconduct who attempt to defend against or mitigate the charges by offering psychological or medical evidence. I'm aware of several instances where such information was set forth in detail in published decisions which informed the world at large that the attorney had been abused as a child or had other psychological issues which were personal and embarrassing. Needless to say, while such details should be reviewed by the fact finders and the court, I believe it's unnecessary to report every detail in the opinions because it appears that the lawyer is being punished rather for having and seeking treatment for such issues. I hope this testimony is received in the spirit that it's intended, not to criticize, but rather to further assist in educating you and the public with the hope that you could have a complete picture of how a lawyer with mental health issue is treated. The procedures set forth in the court rules need uniformity in 3 respects: incapacity, medical and psychological evidence, and diversion. Take incapacity, for instance. In the first and second department, the rule is pretty uniform, and I set it forth for you. But even in this context, there are some variations and inconsistency. Harmonizing these rules would provide a clearer policy and guidance with respect to incapacitated lawyers. In the third department, there's a 2-part rule. And in the fourth department, there are 2 separate rules. The characterizations are different, though. There are references to incompetent, alleged to be incapacitated, incompetency, or involuntary commitment or disability. And I ask you, does a disability constitute incapacity or incompetency? What constitutes an involuntary commitment? Does the reporting rule, RPC 8.3, require a lawyer to self-report or another lawyer who knows of a lawyer who falls under one of these categories to report the impaired lawyer to the court or to the committee? I believe we need uniformity and consistency to define the terms so that lawyers, as well as counsel to the committee, the public, and the courts all understand the parameters of such issues when they arise in the disciplinary process. These changes will afford the impaired lawyer with the necessary notice to have them have due process when faced with issues of impairment, whether such issues stem from or are related to physical or mental disability or incapacity. Now, as to medical and psychological evidence, while all 4 departments accept it, the second department actually has a rule that provides for what you should do when you offer medical or psychological testimony. It provides that counsel, meaning defense counsel, must give 20 days notice prior to hearing and sign waivers to allow the committee access to the records of the medical or psychological professionals and treatment providers. And I believe it should be uniformly adopted in all departments because it gives the parameters. As it stands, once such evidence is offered in evidence or mitigation, the attorney who put the issue forward is subject to the dictates of the committee staff as to what records they must provide. While we recognize that the lawyer raised the issue and that staff is obligated to challenge the veracity of any such defense or mitigation, there have been instances where skepticism and lack of sensitivity is discouraging. On occasion, my witnesses have reported some committee counsel skepticism as to a lawyer's treatment plans and support systems. Moreover, this rule from the second department is a good start as to the parameters of notice and waiver, but it needs expansion to allow for medical and psychological issues as a defense, and also a section that allows for maintaining confidentiality and sealing of such evidence in the record. This is particularly important, and I'll explain later for reasons that I'll explain later. Lastly, diversion, and this is a very important rule. As you no doubt will hear again, we have diversion rules in the second, third, and fourth departments, but not in the first department, and while they will do that informally, there is no specific rule laying out what the guidelines are. So, also diversion is limited to treatment for addiction issues, but not psychological issues. So really, we have a very limited rule where diversion explains if you're addicted to drugs or alcohol, you can divert your issue and the investigation while you seek treatment. It doesn't quite make sense when you look at the DSM-5, which is the guidelines, because addiction comes under one of the categories of psychological treatment. From a lawyer's assistance programs, they do look at the psychological issues, but that does not afford lawyers diversion in each of the departments. So it's my view that if all departments would have a uniform diversion rule, which expands to include psychological as well as addiction issues, that would be helpful because lawyers will be informed as to what will happen if they seek help. Second, addictions, as they are classified under mental illnesses, diversion should be expanded that way. Lastly, my experiences. I'm going to relate some stories to you, and they're anecdotal, but I think they're important, and I can assure you, yes? Okay, so I'm going to just give you one experience, and then I'm going to wrap up. There was a lawyer I was prosecuting, and he was hospitalized because he was bipolar. And he called me, and we were in the middle of proceedings. We were getting ready to disbar him because he failed to cooperate with the committee. And what he said to me was, I need an adjournment from the court. And I said, okay, what's going on? He said, I'm in the hospital. I said, well, I'll inform them that you're in the hospital. He said, no, I would rather be disbarred. I would rather be disbarred than go out on a mental health issue because I will never be able to come back. And what I implore you, and you could read my comments, is that most lawyers try to do the right thing. In my practice, I've seen that there are about a third of lawyers who do the wrong thing, there are about a third of lawyers who make mistakes, and there are about a third of lawyers who have some mental health issues or some stressor that is leaning on their practice. That last third is who we should help. We need uniformity. We can get them treated, and it is very rewarding to work with lawyers, assistants, professionals, to get people back on track and let them regain their career. If we do that, they can then again serve the public. So I'm asking again that we have a diversion rule, that we have some uniformity in the medical and psychological testimony that's given, and that when it comes to incapacity, and this is important, if you take a look at the cases upstate, how they're reported, and the cases how they're reported downstate, you can tell people, and you should inform people when an attorney has been suspended for incapacity, but do you have to give every little detail? Is that fair in what we do? Lawyers can get back on track. We should make sure they get back on track. And I'm hopeful that you will consider my testimony and consider a diversion rule and uniformity with respect to medical and psychological issues. Thank you.
Thank you.
Thank you very much, Ms. Scalise, for appearing this morning. I also am personally grateful to hear you address this subject, which has not had widespread discussion in the hearings, because I think it's a very important component to consider in terms of us reforming the process. And also, based on my own experience, we share high regard for those individuals that serve in the Lawyers Assistance Program to address these problems. But I want to ask you two specific questions with respect to diversion. And I have some interest in that because I served on the commission run by Judge Bellicosa that enacted that proposed rule, which was adopted in some of the departments. But one of the main reasons driving that rule was it was intended, or it was designed to have early intervention with lawyers who had not crossed the line yet into serious misconduct as a result of their addiction or other problems. As time has gone on, and my friends and lawyer assistants agree, the rule has not served that purpose. We have seen relatively very few cases of lawyers proceeding with requests for diversion. I'm interested to know from your view, based on all your experience, why you think that is. Is there a problem in the rule itself? And if the rule is not working for that intended purpose, why would we expand that rule? Why would the courts consider expanding the rule to include the mental health portion of it if it's not accomplishing what it's set up to do?
Diversion was, and actually it came out of this Bar Association, I believe, in some other reports. Diversion really was thought about for people who were making minor mistakes, and maybe there was something else going on. In our practice area, we usually see it because maybe there was a DWI arrest, which has nothing to do with the lawyer's practice. But of course, they're lawyers and they're sworn to uphold the law, and if they're arrested, they can be prosecuted. So having said that, diversion really is for getting people back on track, okay? And whether it's psychological, and there are psychological issues that people have. For instance, the person who I had prosecuted who was bipolar, he stopped taking his medication. So they have to actually participate fully, the lawyers, in order to get the diversion. And it is vetted by both the disciplinary committees, the grievance committees, as well as the court. So there's a whole process that's involved in that, and that means that the lawyers have to do the work. when it comes to lawyers' assistants, they don't just say, this is my defense, take it or leave it. They are monitored. They must sign a contract. They have a lawyer who monitors them regularly. They usually have psychological treatment. If it is an addiction, they generally go through an addiction dry out program, and then they will probably participate in either Narcotics Anonymous or Alcoholics Anonymous. It is a great deal of work, but what I will tell you is I was skeptical too. When I was a young prosecutor, I'll call myself a brat, because I thought, how could someone who is so smart do something so stupid? But when someone has a psychological or an addiction issue, they're not themselves. It is something that is a pull that they don't see and they can't self-diagnose. If they are now confronted by the system and there is a tool to help them, sometimes it helps us too as defense counsel, because we get someone back on track. They don't see that they have an issue. They don't see that there's a problem, but we recognize it from years of experience so that we can get them the help. And by getting them the help, they then will do the right job for their clients. There are certain people that are never going to get the help. We understand that. But if they're willing to work, I did have a successful case where our client did do the work for 2 years after a DWI, and now, we're dealing with the diversion and we got a dismissal. That was important to her because she had a long history, and she was glad for me to relate that to you in my testimony. So what I'm saying to you is, sometimes lawyers can get back on track, and we need those guidelines and parameters so that we can help them, because most lawyers, I believe, are honorable if you look at the statistics. Yes, this is a disciplinary process. Yes, I've been part of both sides, but there are some people whose mistakes can be corrected if we can use lawyers' assistance and diversion to help them.
Can you just comment, based on your experience, the impact of the funding for the Lawyers Assistance Program, let's say over the last 7 to 10 years, how it's changed, and the significance of that in your view?
I think that they very often do God's work in lawyers' assistance, because they're not judging lawyers, they're assisting lawyers. So they listen to the problems, and they have an affinity for what types of stressors the lawyers have. I know that this past year, OCA saw fit to give additional funding to lawyers' assistance, and it's much needed. They never say no to people. Pat Spataro and Eileen Travis and their team of people, as well as volunteers through the bar associations, can be reached day and night. They will call people back. If someone is in a crisis, they will help them. And I think that's really important to understand. We are a helping profession. I would ask any lawyer in this room, why did you go to law school and why did you become a lawyer? To help people. And that is what Lawyers Assistance does, and we work with them regularly, and they help people regain their lives and their careers. And I think that's something that is very important and should be well funded.
There was a time when it was defunded, correct?
It was defunded. There was a Lawyers Assistance Trust, and because the courts were so lacking in funds, they had to do away with it. I'd be hopeful to see that come back, because they were at one point offering grants to different bar associations. And right now it's a piecemeal process, but what they do with so little is very admirable and helpful to lawyers and judges throughout the state.
Thank you very much.
Thank you.
Ms.